This is tax attorney Parag Patel here to talk to you about the U.S. taxpayers residing outside the United States who wish to try to file under the Streamlined Foreign Offshore Procedures. This is a very technical program, but specifically what I wanted to talk about today is the non-residency requirements applicable to individuals who are U.S. citizens or green card holders. Specifically, it's a very specific, it's a very, black and white test. The IRS website, and this is the relevant site, says that you basically have to live outside the United States for 11 months, or in this case, 330 full days over the past most recent 3 years for which you have a tax return that's due. So basically over the past 3 calendar years, have there been 11 months consecutive on 11 months, or not, basically 330 days, doesn't need to be consecutive, but 330 days that you've been outside the United States in that one calendar year out of the past 3 years. So unfortunately, we've had lots of different scenarios, people going in and out, getting in and out, sometimes medical, sometimes COVID, they come here and they can't go back to their country of origin. And unfortunately, the IRS has not come out like they've done in other areas of the tax law. And they haven't said, well, if you're here involuntarily, that time doesn't count. If you're here for medical reasons, that time doesn't count. Basically, the IRS has stated that it's 330 full days. You have to count the days, and you have to be 330 full days outside of the United States in any of the past 3 calendar years. So it's quite simple, unfortunately, and there's not a lot of detail here. Now, most of our clients that we filed this for, we've probably filed about 200 of these cases through this program, have successfully gone in. In fact, all of them have successfully gone in. We've had no problem with this program. The IRS seems to be welcoming people with open arms. We are very responsible when we put people into this program, but we carefully select them and we make sure that they're appropriate for this program. But if they are appropriate, our success is really almost, is 100%. The website goes on to go through a couple of examples, which are pretty clear cut. But I wanted to just make sure that people understood that this 11-month period, 330 day requirement, requires, it is what it is. You do not need to indicate which year. The old form used to require it. As a certification, but now you just have to, this requirement is just in the legal language with the certification. You're saying that you have good records, you're non-willful, and in this case, you fit the non-residency requirement. So that's something that everyone really should be well aware of. We've had discussions with the IRS on an anonymous basis with different clients. And the IRS has stated to us that they haven't had really, they're not auditing people for this particular program for the most part, and they are accepting them, pretty with open arms. So I am, I think it's a great program for clients, and feel free to contact us if we can help you out. We stand ready. I hope this is helpful to you. And let us know if we can help you out further with respect to this program, which has been very successful in our experience.